I always come here. I always love coming to this group. The topic today, as you know, is legal update. That means new laws, new forms, and new stuff. And you can ask questions. And I think, Jody, you can just yell them out whenever they ask. You know, we got very informal here. Big picture stuff before I get into some more specific stuff. As you know, as you probably know, there've been a lot of storms recently, a lot of rainstorms, and there are consequences to that. One of them is a good one. 51 of the 58 counties in Los Angeles have been including this one. I'm sorry, in California, 51 of the 58 counties in California have been designated as, you know, states of emergency type stuff, such that your taxes don't have to be paid until October 16th. How do you like that? And that's state and federal. More particularly for real estate, a whole different analysis. 47 of the 58 counties have been deemed to be states of emergency for purposes of what they call the anti-rent gouging laws. Meaning, if your property is in a county that is under, remember we had all those COVID states of emergency. Now it's just storm related state of emergency. But what that means is you can't increase the rent of your tenant by more than 10%. Normally, if you have a single family house and the COVID stuff is over as it is, you can increase the rent as much as you want. But right now, nobody in most of the state, this county in particular, can increase anybody's rent, residential, not commercial, by more than 10%. Speaking of that, so that's one thing to remember. But even when these states of emergency are over, remember we have something in California called the Tenant Protection Act, which says if your rental property is 3 or more units or a duplex that's not owner occupied, and your rental property is 15 years old or older, and that's 15 years as of today. So maybe yesterday your property was 14 years and 364 days old, in which case you weren't under the Tenant Protection Act. But as soon as you hit 15, your property's under the Tenant Protection Act. What does that mean? That means you can only increase your rent by 5% plus the inflation kicker with a maximum of 10%. So last year, the inflation amount statewide was 5%, obviously. So 5 plus 5 is 10. We're ready for the new numbers to come out for this year. They were supposed to come out April 1st. They're always late. So, but for now, just maximum 10%. We suspect the new number is also going to be 5% like last year, 5 plus 5, 10. So it's very likely that the maximum you can increase someone's rent if your property is 15 years old and 3 or more units, or a duplex that's not owner occupied, is still going to be 10%, even when the state of, regardless of the state of emergency. Okay. So stay tuned for that. But then people say, okay, great. I have a newer building, or I have a single family home, or I have an owner occupied duplex. How much can I increase the rent? As much as you want. However, there's one thing that people always forget. There was this COVID law back when this law passed. Let me cut to the chase. If you have a single family home and you want to increase someone's rent by more than 10%, you first have to give your tenant a form called the RCJC, Rent Cap Just Cause Addendum, where you're basically telling the tenant, since this is a single family home or whatever, we're exempt from that law. Now, if you use a CAR lease form, that document has been incorporated into it for about 2 or 3 years, so you're good. But let's say you've had a tenant for like 5 or 6 years. You've never given them that form in the meantime. You haven't raised their rent. Now I'm going to raise the rent 30%, 50%. No, first you got to give them the RCJC and wait 60 days. Then you can increase their rent as much as you want. You know what the theme here is? It's so much more complicated than it used to be. 3 or 4 years ago, landlord-tenant law was a lot more straightforward. So I would say before you increase someone's rent, You always have to ask yourself, how old is the property? How many units is it? Am I in a city like San Jose that has its own restrictions? And am I in a state of emergency? And the same thing applies to evictions. Evictions are not as simple as they used to be. COVID is over. That's good. But did you know that if you have a tenant who during COVID asserted their right to delay paying rent because of COVID, even though COVID's over now, you still can't evict them for that back rent. You can sue them for the money, but you can't evict them. Now, but thankfully now, everywhere, including here, if someone doesn't pay the rent today, you can evict them. And it doesn't matter whether they have a COVID excuse or not. Well, that's good. But there's one more thing, and that is there's still this law that a lot of people never heard of and they don't realize it's there, that says, if my rental property, I don't care what type of rental property it is, if I purchased my rental property with a federally related loan, which means not just FHA-VA, it means I got a conforming loan. I got a loan, that had to meet Fannie Mae or Freddie Mac standards. If that's the money I used to buy the rental property, there's still a law that hasn't been repealed yet that says if someone doesn't pay rent, I got to give them a 3-day, obviously give them a 3-day notice to pay, but you got to give them 30 days to leave. In other words, normally if someone doesn't pay the rent, you give them 3-day pay or quit. That means 3 days, either pay or leave. And if they don't do one of those two things in 3 days, you can start the eviction. But if your rental property was purchased or securing a loan, a federally related loan, you can still give them 3 days to pay. But if they don't pay, you got to wait 27 more days until you start the eviction, which means they get 27 days of free rent. What if somewhere in those 27 days they give you money? You don't have to take it. Don't take it, because if you take it, they're back. You can't kick them out. You cannot take it, but you can't force them out. But you know what? This is a federal law. We found a lot of California courts don't even know about this. So we're seeing evictions going on there where they give them the 3-day notice to pay or quit. 3 days go by, they don't pay, and they start the unlawful detainer. And the tenant, either they don't have a defense attorney or their attorney doesn't know about what I just said, and they just let it go. So don't tell your tenants about they have this right, okay? But they do. Okay, so you see, moral of the story is landlord-tenant law is 10 times more complicated than it used to be. Before you either try to evict someone or raise their rent, it's probably a good idea to call a lawyer first, like the legal hotline, because we will figure it out for you. And then, of course, San Jose has its own rules. Santa Clara City, as far as I know, might have its own rules. It's a very complicated area. All right. Anything else we have to talk about for tenants? No, I think that's about it. One more big picture thing that's been coming up recently is, okay, all these rainstorms we've had. Sometimes what happens is, what if right in the middle of an escrow, there's some rain and there's a leak or something? There's a problem that occurs to the property in the middle of escrow. Does the seller have to fix it? Yes. Because they have to maintain the property just as it was on the day of acceptance. And you know something, even if the escrow has closed and the seller is now a tenant, so the buyer owns the property, but something happens to the property during the seller rent back, it's still the seller's responsibility to fix it, even though they don't even own it anymore. Why do I say that? Because that's what it says in our form, in our rent back form. I'm assuming you're using our rent back form, the SIP form. That's what it says. And that's an issue that's been coming up. Okay. All right. So enough on the big picture, weather related stuff and the big picture stuff on rental properties. We're going to talk about California laws. Another general comment. You know how many laws get proposed every year? Usually around 3,000. This year already about 3,000 laws have been introduced. How many of those usually get all the way through, so they're passed and they go to the governor's desk? About half, 1,500. How many does the governor usually sign? Usually about 1,000. Last year was exactly 997. And our lobbyists in Sacramento read every law to see if it's good for real estate or not. And if we don't like them, we try to oppose them. And usually we're very successful. This past year, we had a great year opposing bad laws. Some of the laws that got to the governor that never got, or some didn't even get to the governor. There was a law that was going to say, if you sold a house and within 3 years after you buy, you got to pay a 25% tax on any profit. Didn't pass. There was a law that was going to say, if you have a tenant occupied property and you want to sell it, you got to offer it to the tenant first, and you can't sell it to anybody else for a couple months while the tenant makes up their mind. Didn't pass. There was a law that said any landlord who has a vacancy, before you can re-rent it, you have to have a state-sanctioned energy efficiency audit. Didn't pass. There was a law that was going to require all home sellers to get their cooling system audited before they could sell. Did not pass. Don't worry about these things. Why am I even telling you about them? To remember that that's why you pay your dues. Most of your dues pays my salary, but the rest of it goes to, just kidding, just goes to money that we have to, I mean, to be very blunt about it, the more money we contribute to politicians, the more persuasive our arguments are when we try to convince them not to vote for a particular law. That is the black and white of politics, but that's just the way it is. So don't feel, I mean, I hope some of you go to Sacramento. Jody was telling you about in a couple of weeks. The more realtors they see,
if I can really quick, Glev.
Yes.
Nobody heard me.
Okay. Oh, that's right. It was all muted.
I was muted, but go to Sacramento, you guys. It's an amazing day. As I was saying, your voices actually get heard.
What day is that, Jody?
May 3rd.
May 3rd.
You can take a bus up with SCORE, or you can carpool up yourself. But Gov is right. Your voices actually matter. So just know that, because we do kill things on the assembly floor a lot of times day of.
Yeah. And the other thing, of course, is, in all seriousness, you pay your dues, thank you, but we always ask if you contribute a little more, and all that money goes to directly political advocacy, which is very important. And I know you have local issues here that sometimes you're successful in fighting too. It's an ongoing process. And guess what? All those bad laws I just mentioned were all reintroduced this year. We've got to fight them all over. So, and every year they try to propose a law limiting the mortgage interest deduction, to primary residence or something, or limiting it to cap it at a particular amount. Things come up every year we have to deal with, so we'll continue to do that. All right, so the governor signed 997 laws. How many of those laws are real estate related? Only about 20 or 30. We have a handout on our website, 2022 new laws, 2023 new laws, which you can access. I'm only going to talk about a handful because they're really not that many significance. And I'm sorry, Jody, unlike normally, I don't have the bill numbers with me. So, okay, you can do your best. Okay. All right. Let's talk about 5 or 10 new laws. Then I'll talk about forms. There are, since I was talking about rentals, I might as well get that out of the way. There are 2 new laws relevant to rental properties. One of them creates something called a reusable tenant screening report. What that means is you're a landlord, you have a vacancy, you have a tenant, they want to apply, and you want to screen them. You may want to hire a screening company like Rent Spree or something to check out their eviction history, their criminal record, their where they work and stuff like that. And you can charge them up to $55 to do this. But now tenants can go directly to one of these screening agencies, pay a one-time fee, and then they can use that screening report for more than one landlord, more than one application. William just had one. Now, landlords don't have to accept that. They can sort of, no, sorry, I want you to do my own. But since it's already done, certified, maybe they'll probably take it. It'll save everybody time and money. So that's a good thing. Second, other law regarding rentals is probably maybe the most controversial new law I'm even going to mention today. It deals with the domestic violence. So prior to this year, the law regarding domestic violence and rentals was, number one, a tenant could say to the landlord, you know I signed a lease, I got 9 months to go, but there's domestic violence going on here. I need to leave. You need to let me out of my lease. And as long as the tenant can produce some type of either police report or restraining order. By the restraining order means they probably can't, bad person can't be there anyway. But the point is, if they produce that, the landlord has to let the tenant out of the lease. But the law also said that as a landlord, if I hear that there is domestic violence going on one of my properties, I can choose to terminate the lease, whether the tenant wants to or not, because I don't have to allow that type of activity in my property. So that was the old law. New law, it still has the first part, tenants can cancel, but no longer can landlords on their own initiative terminate a lease. In fact, the victim, the alleged victim, can now say to the landlord, there's domestic violence. So here's what I want you to do. I want you to do a partial eviction. I want you to evict the bad person. I'm staying, they got to leave. And you have to change the locks too. And of course, the landlord has to pay for this. Now, the only proof that the alleged victim has to provide is, once again, police report, restraining order, or even there's a third category now, reasonable documentation from a reputable source. What the heck does that mean? That means perhaps a victim's advocacy group investigates the issue, makes a good faith determination that there is in fact domestic violence going on. That is enough for the tenant to compel the landlord to evict the bad person. Now, the law also says the court can say as part of this that, okay, tenant who's still there, we're doing this, but if you allow this bad person to come back so much as visit one time, that's grounds for the landlord to terminate the entire tenancy, including you. Also, the law also says that if in the landlord's judgment, reasonable judgment, this bad person poses a threat, not just to the person they're living with, but to other tenants. You've heard of that type of complete jerk, starts threatening the neighbors and everybody. That's grounds for the landlord to evict everybody, terminate the entire tenancy. There's also a statutory penalty of like $5,000 if you violate this. You know what I'm really telling you? If you ever come into this situation, call a lawyer, call a hotline. We'll figure out what you actually have to do, what you should do. I mean, it's fairly controversial, fairly complicated, probably the most difficult new law that you have to deal. I mean, it's already hard enough to be a landlord in California. It's so complicated. And I hate to tell you this, the DRE has told us the number one currently the number one thing we're disciplining realtors for is realtors doing the wrong, giving the bad advice regarding rentals, or being a property manager and not doing it right. In other words, not following all this crazy stuff I just mentioned. So that's why you need to talk to a lawyer. And better yet, if you're not a property manager and your clients who happen to have tenants ask you questions, you try to not answer. You try to say, you should have talked to your own lawyer probably, or at the very least, you call us so we make sure you're doing the right thing. Okay. All right.
Question.
Yes.
Actually, there's a question on Zoom and I have a question.
Okay.
The question on Zoom is, what happens if the remaining tenant does not qualify to pay rent?
Yeah, that's a great question. In other words, the quote unquote bad person is the one who had all the money. So can the landlord say, okay, I'm going to kick that person out, but you have to re-qualify with me now to prove that you have enough money to pay the rent without that person? No, you can't do that. However, of course, if the person who remains doesn't have enough money, that's going to become pretty obvious pretty soon if they don't pay the rent. Then you can evict them for not paying the rent. They don't have the right to stay and not pay rent. And your question, Jody?
My question, does domestic violence have to be between people? And I asked because I had a situation, I was living somewhere. The person above me was unstable.
Yeah.
And actually, when I was slowly moving out, came after me and was very verbally assaultive. Can that be seen as something that's domestic violence, even though that's somebody who lived above me that was threatening me?
Yes, it could. In other words, it doesn't just mean a threat from the person you're actually living with. Usually that's the case, but not necessarily. But that comes under the more general rule. Landlords have an obligation to protect their tenants from other tenants. And in your scenario, the other tenant was a threat, was a danger, etc. So forgetting any new law, that's a general rule. You have to evict bad people. Otherwise, if one of your tenants you're aware is doing bad things or threatening bad things and you don't deal with it, and then they actually do a bad thing, that the victim can sue you. You knew about this bad person, you let them stay. One more thing, another challenge for being a landlord. All right. Few more new laws to talk about. No more rental stuff. There's a couple of new laws on the general theme of, I would say the theme is making it easier to build accessory dwelling units. Let me back up for a second. You might remember a year ago when I spoke to this group, I told you the most important law for 2022 was something called SB 9. That's the law that says I own a house on a single family lot. So it's zoned for single family, even though that's the zoning. And it used to be the only way to build something else, you'd have to get permission from the government. You have to get a variance. The law SB 9 said, nope, you don't. If you have a single family property, you can always build another unit. You can add a duplex, make it into a duplex, and the city can't stop you as long as you get a building permit, et cetera. I mean, they can require a setback, a reasonable setback. The setback, I mean, can't be so too restricted. Anyway, typically a 4-foot setback. And if the lot was at least 2,500 square feet, you could probably do a lot split and put 2 properties on each one. So everybody can turn their single family home into a 4-plex. Remember that big deal? It's not happening. Nobody's doing it. You know how many single family lots there are in California? Oh, like 10 million. How many of those single family lot owners took advantage of that law last year? 292. That is not many. You know why? Because even though that law sounds promising, there's so many restrictions preventing you from doing it. First of all, builders can't take advantage of it because you can only do it on one even if you own 2 properties next to each other, you can only do it on one of them. So like a builder can't buy up a street load and then start doing it on each. No, they can only do it on one of them. So that's one thing. Another thing is if the property in question is in an earthquake zone, flood zone, fire zone, can't do it. Well, that's half the state, right? Then there's if it's in a historic district, landmark district, protected habitat, can't do it. Did you hear about that city? I forget what it was. It was in the Bay Area where they passed a local law declaring that the entire city was a protected habitat for I don't even remember what the animal was.
I think it was Los Altos. And
I think it was Los Altos.
It was like coyotes or something
weird. And they got overturned in court. But the point is, but you know what the real obstacle under SB 9 is? If you're going to do this, you have to commit to live in the property for the next 3 years. Well, guess what? That means you're going to have to live there while you're doing the construction, building the new properties. Nobody wants to live on the lot while they're building something else, but you have to be able to. And the point is, it's not happening, but the point is people are doing something else. They're building ADUs, and approximately 20,000 were built last year. It's going to be more this year. And now it's even easier to build them. Oh, by one other thing about SB 9, HOAs can prohibit you. So under ADUs, you have the absolute right to build one. And HOA can't stop you. Doesn't matter if you're in an earthquake, flood, fire zone. Sometimes it matters, but rarely does. Doesn't matter you're in a landmark district. It doesn't matter. You can actually we can all do 2 ADUs. We can all convert existing space like a garage, and you can add on another one. When I say you can do it, I mean, the city doesn't have discretion to say yes or no. As long as you get the permit and follow the building code, you have a right to do it. But you still got to go through a process of getting approved. New law says 2 things. Number one, it says they have to give you an answer within 60 days. Otherwise, you can just build it. Second, they can be bigger than they used to be. It used to be the city could restrict you to an ADU that was 16 feet maximum and 4-foot setback. Now the rule is they can't have a setback requirement that makes it impossible to build, and it can be 18 feet high if the property is within a half a mile of either a bus stop or a major thoroughfare.
Ah, what a joke.
Which right now I'm looking at First Street, which is considered a major thoroughfare where there's, transit stops along it. If you're within a half a mile of that, it can be 18 feet high. And if the ADU is attached to the property rather than detached, it can be 25 feet high. So in other words, not only is it pretty easy to build ADUs, now you can build them quicker and bigger. So they're trying to incentivize ADUs, obviously. Another thing related to this, you have an absolute right to rent out your ADU. What about homeowner associations? Can HOAs tell you you cannot rent out your property? Normally they can. Normally an HOA can say, all right, only 25% of the properties in this development or this building can be rented. But let's say it's a single family home development and you have an AD, the law says if you're only renting out a portion of your property, that doesn't count towards the 25%. You have an absolute right to do it. So let's say I got a house and an ADU and I want to rent out the ADU. You have the HOA can't stop you. That's not part of the maximum of 25%. You can even live in the ADU and rent out the main house. And that doesn't count as renting the whole property. So that doesn't count toward 25%. So you have the right to do that. So that comes up sometimes. Yeah. Yeah. I should point out, good question, that cities, counties, and HOAs can prohibit short-term rentals like Airbnb. They can absolutely prohibit rentals less than 30 days. So that hasn't changed. Let's see, anything else we should know about ADUs? Not really. There's also the question, sometimes the city will say, okay, you can build your ADU if you create new parking on your property, because you're adding living space, you also must add parking. And once again, similar rule, if the property you're talking about is within half a mile of a transit stop or a major traffic corridor, once again, they cannot require parking. And there are even circumstances, even if you're not within a half a mile, where they cannot require extra parking.
Wow.
Having said all this, there are still cities out there and some HOAs that are still fighting back and not approving it and trying to stop you from doing it, even though they don't have the legal right to do that. And so much to the extent that CAR has hired 2 lawyers whose only job is suing cities who don't allow property owners to build what they have the right to build. Usually it's ADUs. So if you or your client is running into that situation where you think that the city, you're not sure if the city is correctly in their decision not to allow you to build, call us. We'll figure it out. If you have a case, we refer it to these lawyers. They'll sue the city, threaten the city, doesn't charge you. They won't charge you. And you know, unlike the hotline attorneys like me, these are mean attorneys. So they're very scary. So don't mess with them. Just kidding. Anyway, related issue. I got a house. It's a 2-bedroom house. I want to turn my 2-bedroom house into a 3-bedroom house or a 4-bedroom house. Not by adding on to it, but I just want to reconfigure the inside, you know, put up a wall or whatever, turn my 2-bedroom into a 3-bedroom. New law says you have the right to do that. That's not something that the city has the discretion to stop if you get the permit. Yeah, you still got to get the permit. Yeah. But I mean, up until now, the city could have said, no, whether you get a permit or not, we're just not going to allow that. Yeah. Yes. No, they can't. By the way, one of the, have you heard about this thing? There are now companies that are building prefabricated ADUs. It's like a mobile home, and you order it, and they bring it in, drop it down from a crane, and plop it down on your house. Yeah. Well, that sounds cool. It is cool. Yeah. So here's a question a realtor asked me the other day. He says, one of these companies contacted me and said, if you refer clients to us to build them these ADUs, we'll pay you a fee, a referral fee, like a commission. And the realtor wanted to know, can I do that? The answer, unfortunately, is probably not. On the one hand, if you have a mobile home dealer's license, yes. This is just a portable, it's a manufactured home. What if I don't? Well, then, okay, it violates RESPA for you to go out and solicit like a referral. You can't like go to all your clients and say, hey, you need an ADU, I got a good place. But if it's a pure finder's fee, you didn't solicit it, your client just happened to come to you and said, hey, I heard about these ADU. Do you know anyone who builds ADUs? So you didn't solicit that, they just came to you. And I know that's a fine line. Then it is perfectly okay to refer the ADU builder and get paid for it. That's just like in real estate in general, right? An unlicensed person, can't pay a referral fee. You can't pay them a referral fee. They can't pay you a fee, but if it's just a pure finder, then it's okay. Anyway, that's almost it for new laws. Anything else we should know about new laws wise? As far as the DRE is concerned, there's really only one new law that came out from them. It basically says, let's say you want to become a broker as opposed to an agent. What does that mean? You got to take the broker's test. But you can't just walk in and take the broker's test. You have to be an agent for 2 years first, or have a college degree in real estate. What's the new law? The new law says those 2 years have to be within the last 5 years. So if someone was an agent 10 years ago for many years, let their license lapse, dropped out of the business, now I'm going to come back. But now this time I'm not going to be an agent. I'm going to be a broker. No, you're not. You're going to be an agent for 2 years again, because unless it was in the last 5 that you were an agent. Also new from the DRE is when you renew your license, the next time you renew it, you still got to take 45 hours, but the 45 hours are slightly different. There's a new class on what's called implicit bias you have to take. And also there is the fair housing class itself has been expanded. So you'll notice that, but CAR still offers it to you. Another DRE/rental issue to remember is fair housing. a big issue right now with the DRE, a big issue with the Fair Housing Department is Section 8. Let me back up for a second. In California, when you're selling or renting real estate, you know you cannot discriminate. You can't refuse to sell or refuse to rent or have different terms for someone based on their race, religion, age, gender, disability, color of skin, gender identity, gender presentation. There's like 24 categories. And one of those categories is source of income. It used to be you could ask someone, what do you do for a living? I'm a lawyer. Well, I hate lawyers. I'm not renting to you just because you're a lawyer. And that was legal. Similarly, you could say to a tenant, what's your source of income? Oh, you get Section 8? I'm sorry, I choose not to participate in the Section 8 program. Do you know you can't do that anymore? Not only do you have to rent to lawyers, bad enough, but you have to take Section 8 tenants. Every landlord in California is now a Section 8 landlord. And the landlord says, wait a second. Does that mean I have to take every Section 8 applicant? Of course not. You can still screen your applicants and you can still reject people based on their credit score, their eviction history, or their criminal background or something like that. But let's put it like this. You get 2 applicants. One Section 8, one isn't. And the Section 8 applicant has a higher income, higher credit score, no criminal record, no eviction problems. Whereas the non-Section 8 applicant, criminal record, been evicted. So objectively, the Section 8 tenant is better than the other tenant. You better not take the other tenant because that's going to make it look like the only reason you rejected the Section 8 is because they're Section 8, which is probably the reason you rejected them. Yes. Yeah, that's a great question from my good friend Sky here. One of the 2 people not too lazy to actually come to this actual meeting. Anyway, so yes, you still have, the government still has to, has to come in and approve your property for Section 8, which leads to a couple of questions. This can take time. They're backed up. I don't know if they're backed up in San Jose, Santa Clara, but they're backed up in LA. They're backed up in Oakland like a month or 2. Anyway, so right. So here, but here's the question. So the applicant says, well, I'll wait. I'll wait till you're qualified. Does the landlord have to delay and wait? Well, we asked this question to the Fair Housing Department. They said, we think landlord should at least have to wait at least 10 days. So, in other words, what if the landlord says, I cannot afford to have this property vacant at all. And they're going to say, you can afford to have it vacant for 10 days. If they're backed up and you got to waste at least 10 days. Okay. Now, but that leads to another question. You got the landlord who desperately does not want to be Section 8 landlord. By the way, I don't know what's so bad about Section 8. I mean, the tenants have the money to pay the rent. But so the landlord says, I'm going to let my property fall apart. So the Section 8 people will definitely not approve it. There have been cases where by the way, these Section 8 is, even though it's a federal law, it is enforced by the local fair housing authority. There have been cases where the Fair Housing Authority has said, oh, you're deliberately just trying to sabotage this process. So you know what, we're going to make you rent to this person and you need to fix this property. And if you don't fix the property soon, we're going to make you rent to this person and they don't even have to pay rent until you fix it. So it's not a catch-all excuse as a landlord to just make sure their property is not compliant with the standards for Section 8. And by the way, the standards for Section 8 are pretty much the same as all rental properties anyway. So the things there are a couple of differences, and I forget exactly what they are, but we could once again call the hotline. We'll help you out if you have an issue like this. But since we're talking about this, there are some people you can discriminate against. For example, did you know you're allowed to discriminate against investors? Whether you're selling or leasing, it's more in a sales situation where you get two offers. One buyer says, I will live here. The other buyer says, we're buying as an investment. It's fair. It's legal to say, well, I'm going to sell. I like people. I want to sell to buyers who I actually know are going to move in. I'm discriminating against the investor. That is legal. Another one, which my good friend Sky actually asked me on a previous day, is can landlords limit how many people? Can they say, okay, on my 3-bedroom house, only 2 people can live here? What they're really thinking is, I hate kids. So if I limit it to 2, that means I'm not going to have to rent to any kids. Well, the government knows that's what you're doing. So the government doesn't give you the absolute right to limit how many people can live there. There's a guideline, unofficial, but the fair housing people tend to follow, of 2 per bedroom plus 1. So if I got a 3-bedroom house and 10 people show up, I can probably get away with saying no. Yeah, I'll get to that in 1 second. So in other words, because 2 per bedroom plus 1, 3-bedroom house, that's 7. So if you limit it to, if you try to limit it to less than 7, maybe not. But if you limit it to 8, 7, no more than 7, you can probably get away with it, even if it's 2 adults and a bunch of kids. You can still have that's still rational and legal to have a restriction on the total number of occupants. Yes. Yes, but you can't avoid that. I mean, the question was, in other words, once you're part of the program, you're part of the program. And every year it's reevaluated. By the way, what if, I'm a landlord, I want to raise my rent next year. And now the Section 8 tenant, even with the subsidy, can't afford it. Well, you're allowed to do that. There are restrictions, like I mentioned at the beginning, on how much you can increase someone's rent. But if you're increasing the rent legally and the Section 8 person doesn't qualify for Section 8 anymore, then I guess you're allowed to get a new tenant, right? Another thing I'd like to mention is, even if you have a single family home and there's no restriction on how much you increase someone's rent, which is true once the state of emergency is over, you still have to be a little bit careful. Let's say I got a tenant, single family house, haven't raised the rent for years. Can I increase as much as I want? Sure you can. But let's say what you're really trying to do here is get rid of this tenant. You don't like this tenant. Do you need a reason to evict them? You really don't, if it's a single family house. But that doesn't mean you can evict them for a bad reason. Like, you got a couple that's lived there forever, and all of a sudden they have a kid. Now there are 3 of them. And all of a sudden you evict them. It looks kind of coincidental that you evict them right when they had the kid. Nobody can read your mind. I'm not discriminating against them. I just want a new tenant. Yeah, but why just because they just had a kid? It looks bad. The other thing is this. I got a tenant paying $3,000 a month. I really don't like this tenant. So I'm going to increase the rent to $4,000. And they're going to say, I can't pay it, and they leave. They say, great, now I got a new tenant I like, and I charge them $3,500. Oh, no, you don't. If you raise the rent to this amount and that tenant left, that means you got to charge every tenant who comes to that same amount, at least for the time being. At some point you can lower it, of course, at market. Right. Yeah. But it looks really bad if you kick someone out because they couldn't pay the increased rent and then you immediately rent it to somebody else for less money. It looks like you were just trying to get rid of that tenant. They're going to say it's because of my race, religion, color of skin, country of birth, blah, blah, blah. Okay. That is pretty much it for new laws. That's pretty much it for the DRE. That's pretty much it for fair housing. Let's talk about forms for a while. CAR, you know from experience, changes the forms twice a year. If there's an emergency, a brand new law, sometimes in between, but usually December, June. So what happened in December and what's going to happen in June? In December, were there any new forms? Yes. Were there any significant changes to any of the existing forms? Just a couple. So from the new forms, there were 10. Don't panic. I predict that 9 of these forms you're never going to use, or 8 of them. But I'll tell you about them anyway. Of the 10 new forms, 6 of them are related to buyer broker. Now, there's no law in California that requires you to have a buyer broker contract. My experience is most California realtors do not require their buyers to sign them. This morning, when I had a group here and there was no Zoom, so everybody had to show up. And I asked the group, I said, who here requires your buyers, every single buyer, to sign a buyer broker contract? Nobody raised their hand. Let me ask the 2 people here. Do either of you mandate your buyers? One of them's actually nodding. She's rare. Then I asked the question, this morning, how many of you ever require or ask a buyer to sign it? And about 4 people raised their hand. Okay. So it's not a common thing, but let me give you the big story here. Have you heard that there are these 2 lawsuits that are happening right now that are, both have been certified as class action lawsuits? We have plaintiffs suing NAR and the big nationwide country. They're suing RE/MAX, Keller Williams, Coldwell Banker, I don't know, eXp Realty, I don't know. They're suing Compass. They're suing the big companies and NAR. And they're saying the way commissions are paid in this country is illegal, violates the antitrust laws. How do commissions work today? Seller pays listing agent pays buyer's agent through the MLS. The argument in these cases is that's wrong. That artificially inflates in commissions. Buyers can't negotiate on the commission. What should be the case is buyers should pay their agent and sellers should pay their agent, not seller pay agent, agent pay. No, that's wrong. That's the argument. And they've been certified as a class action. It doesn't affect California though, because both of these cases are outside of California. One of them basically, everyone who sold a house between 2015 and 2021 in several Midwest states are part of this suit. So if they win, they each may get some of their commission back that they paid. CAR is not a defendant. No California transactions are involved. So why do we even care? We care because if the plaintiffs win this case, the rules will change and that'll affect everybody. So what's possible? It's possible that in the future, buyers will have to pay their agent directly and sellers will pay their agent directly. Do I think this is a likely outcome? I really have no idea. I do know that these cases aren't even going to trial till 2024. Whoever loses, I'm sure there'll be an appeal. This will drag on. But it is possible that in your lifetime, in the next few years, at some point, the law will actually require buyer's agents to have a buyer broker contract. And the only way for you to get paid would be for the buyer to pay you. So, by the way, even apart from these cases, there's movement in the legislature to require buyer broker forms, even regardless of these cases. So things might change. Why am I telling you this? Because the forms committee is sort of ahead of this. First of all, so what are the 6 new forms? First of all, we have a buyer broker contract, a new buyer broker form. It's not required. It may never be required, but it's there. Somebody say, well, I thought we already had of course we already had, we used to have 3 buyer broker contracts. One of them was like an exclusive listing. It says buyer agrees that if I buy anything in the next 60 days or whatever, I will make sure you get paid whatever, 2.5%, 3%. Then we have a non-exclusive one that says, if I show you a house that you buy in the next however many days, you pay me. And the third one doesn't involve money. It just says, I'm your buyer. You're my agent. We have a contract, but I'm not committing to pay you. Those 3 forms have been combined into one, BRBC, Buyer Representation Agreement. It defaults to being a non-exclusive one. It basically says, if I introduce a property to you and you buy it in the next period of time, you make sure I get paid. You can check a box and turn it into an exclusive, or if you don't want it to involve money, you just write 0 in the compensation. This is not required. I think it's a good idea to put your relationship with your client in writing, talk about what your duties are, what their duties are. And it, of course, also protects you from the buyer who, totally betrays you. You find that you work with a buyer for months, finally bring them a house that they really want to buy, and then they go right up the offer with their brother-in-law who just got his license yesterday. Now, if that happens, even today, you do have a remedy. You can take the brother-in-law to arbitration at the Board of Realtors, where the brother-in-law is a member, arguing that you are the true procuring cause. They're not. You should get the money. You can do that. But if you had a buyer broker contract, you could just go directly to your buyer and say, you owe me the money. Okay. Buyers don't want to sign these. Why? I don't know. They don't want to commit themselves to you. And they don't want to pay you. Well, first of all, they don't really have to commit themselves to you indefinitely, because on the buyer broker contract, it says either side can cancel at any time. Okay, but they really don't want to pay you. Well, chances are they don't have to, because even if you have the buyer broker contract that says buyer is promising to pay you X, chances are they're still not going to have to pay you even if they buy something, because it says in that contract that any money the agent receives from another source is a credit against what the buyer owes. So in other words, even if you have a buyer broker contract where the buyer is, for example, promising to pay you 2.5, chances are you'll end up writing an offer on a listing in the MLS where the listing agent is offering you 2.5 or 3. So in that case, even though you had a buyer broker contract, the buyer doesn't pay you anything. The only time the buyer actually pays you is if, for example, you have a buyer broker contract where the buyer has agreed to pay you 2.5, and then you end up writing an offer on an MLS listing where the listing agent is only offering 2. In that case, buyer promised you 2.5, listing agent's only paying 2. Okay, the buyer owes you 0.5%. That scenario does exist. Having said that, there is a new reason why it's a good idea to have a buyer broker contract. Remember, I just told you that scenario where 2 agents are arguing with each other on who's the procuring cause, who deserves the MLS commission? Just a couple months ago, they changed the procuring cause guidelines. It now says, if 2 agents are in a dispute over procuring cause, and one of them has a buyer broker contract and one of them doesn't, the one who doesn't is probably going to lose. So let's get back to my scenario where your buyer betrays you and goes to the brother-in-law to write up the offer on the property you found them. In the old days, I would say you'd probably win that case. But let's say the brother-in-law has a buyer broker contract and you don't. You might lose. You probably will lose. So it's a good idea to get a buyer broker contract. Even you can just, so the buyer's not scared that they're ever going to have to pay you can write 0 in the compensation part. But at least that protects you as far as this procuring cost. If both of the agents have buyer broker contracts, they sort of cancel each other out. So just something to think about. All right. So 10 new forms, right? 6 of them buyer broker related. The first one is the new consolidated buyer broker form. What are the other 5? They're all related to this. Remember how I just said that if the buyer is, either side can cancel the buyer broker contract. Well, let's say you have a buyer broker contract, the buyer 2 weeks into it cancels you. But then they end up buying a house that you showed them during those 2 weeks. You still get paid. But you first have to submit, when it's canceled, a list of the properties that you introduced them to. So we got a form for that, notice of broker involved properties. A third form relates to what I just said. We have a cancellation of buyer representation form. A fourth form is just a generic buyer transactional advisory, BTA, which is just sort of explains to the buyer this whole concept of buyer brokerage. So those are, if you don't use buyer broker forms, you're not going to use those other 3 forms either. So that's 4. 2 more. One of them deals with a related issue. And the issue is, as a buyer's agent, do you have to tell your buyer how much you're going to get paid if this deal closes? Currently, the answer is no. And I'm sure if everybody on Zoom, if I ask you to raise your hand, if you tell your buyers how much you're getting paid, nobody's going to raise their hand. Agents, in my experience, typically don't do that. There's a possibility that one day you might have to do that. It could be required that, just like a listing agent, you have a listing contract where you're telling your seller how much you get paid because they're paying you. It's possible that whether you have a buyer broker contract or not, you're going to have to tell your buyer how much you get paid. 2 points to that. Number one, even today, they can figure that out, It's in the MLS now. The MLS discloses to the public how much the listing agent is offering. But that doesn't mean you have to bring it up. It is possible one day you might have to bring it up. We already have a form. It's easy to remember the initials. It's the ABCD, Anticipated Broker Compensation Disclosure. So if you see this form on Zip Form, don't panic. It's not required, at least not yet, maybe never. But let's go back to the buyer broker contract. If you have a buyer broker contract where the buyer has to pay you, it is required. Think about it logically. You have a buyer broker contract, your buyer is agreeing to pay you 2.5%. They want you to present offers on 3 houses. One of those houses, the listing agent is offering 1.5%. One of them, the listing agent is offering 2%. One, the listing agent is offering 2.5%. So if the buyer buys this one, 1.5%, they owe you a percent. If they buy this one, they owe you half. If they buy this one, they owe you nothing. You have to tell your buyer how much they're going to end up paying you if they buy this one as opposed to this one. And that's always been true, by the way. And now there's a form to do that. Okay. All right. Okay. So those are 5 forms you may never use. Now I'm going to talk about, in the process of telling about the 5 remaining forms, I just want to talk about a couple changes to the purchase contract that happened in December. You may be aware of these already. Maybe you haven't noticed them yet. It's worth talking about. One of them relates to the buyer broker situation, and it relates to the 6th and final buyer broker form that's new. Purchase contract now on paragraph 3G3 has a box where the buyer can check a box. And if they check the box, it says seller agrees to pay the obligation of the buyer to compensate buyer's broker under a separate agreement. The scenario is this: I have a buyer broker contract. The buyer is agreeing to pay me 2.5%. Now I write an offer for my buyer on an MLS listing where they're offering 2. What that means is the buyer now owes me 0.5% because they promised me 2.5. The listing agent's only giving me 2. So you owe me 0.5. The buyer now has the opportunity to check a box, and they're saying to the seller, it turns out I owe my agent 0.5%. I want you to pay it. Obviously, the seller can say no. I mean, obviously, you can ask the seller to pay anything. Seller, I want you to pay my kid's college education. Seller can say no. Just like anything, you can ask seller to pay closing costs, seller to pay my transaction coordinator's fee, whatever it is, you can ask, and sellers can say no. So you could have asked this anyway, but now we have a nice checkbox where you can make it simple. The point is, all of you who don't use buyer broker contracts, you're never going to check that box. Even if you do have a buyer broker contract, rarely does the buyer actually owe money anyway. And even if you're in one of those rare cases where the buyer does owe their agent money, they don't have to check the box. And even if they do check it, the seller can simply say no. What we're hearing, though, you tell me, well, there's only 2 of you that can tell me this. We've heard from listing agents that they're getting offers where that box is checked. So if they know what they're doing, they say to the buyer's agent, okay, show me your buyer broker contract. So you see how much they're paying you, so I know what you're asking. And they say, oh no, we don't have a buyer broker contract. Then why did you check the box? Oh no, it's a new thing. We have to check it. It's required now that you have to confirm the commission and the blah, blah, blah. And there is a form attached there, form called the SPBB, seller payment to buyer broker. And they attach it and they want you to sign it. They don't know what they're doing. They're confused. You can try to educate them, or you can simply say no. Counter it out. That's what you should do. Just counter it out. Okay. All right. So that's one thing. So that's the 6th and final buyer broker related form that came out in December. Most of you are never going to use these forms. You know what I can imagine happening, though? Imagine 3 years from now, the rules change and buyers now have to pay their agent directly. Sellers have to pay their agent. Well, you know what's going to happen? Listing agents aren't going to be able to get 5 or 6% listings anymore because the seller's going to say, well, you don't have to pay the buyer's agent anymore. So I'm just going to sign 3%, 2%, whatever. And then the buyer's agent is going to say to the buyer, okay, you got to pay me 2.5%, 3%. And the buyer says, I can't afford that. I'll ask the seller to pay. So they'll check this box and they'll say, seller, you need to pay my 3% commission to my agent. And the seller will probably say yes, which means we'll be back to exactly where we are today. Sellers paying 5 or 6, buyers paying nothing. Who knows? The point is, I guess the form is ready for this, if it ever happens. Okay. Couple more changes, 3 more changes to the purchase contract. One of them is paragraph 3M3. You know, when you buy a house, you have a closing date, right? Right. But you also have a move-in day. I mean, the day the buyer gets to move in is not automatically the closing day. 2 different things. The question always is, what's the closing day? Well, that's on the first page. The next question is, when's the possession day? That's paragraph 3M, second page. And you know, there are 2 categories. It says, am I buying a seller occupied or vacant property? That's one category. Or am I buying a property that's occupied by other people, like tenants? Well, let's say it's a seller occupied let's say it's vacant, it's easy. You know, you figure out what day the buyer gets to move in. If it's seller occupied, the default is sellers will leave at close. But you can check a box and give the seller more time. That's fine. Or if it's tenant occupied though, then you don't check the seller box. There's another box that's okay. So if it's occupied by tenants, when do the tenants have to leave? Well, there's no place in the contract up until now that addressed that. So it says, it has always said in paragraph 3M that if the property is occupied by tenants, the buyer should attach to their offer the TOPA, tenant occupied purchase addendum. That's where you're basically saying to the seller, I want the tenants out by whatever. You know what we've noticed? Buyers are not using this form. Even though they're buying a tenant occupied property, they don't use the form. So now there's uncertainty about when the tenants are leaving. So here's the change to the form. The form now says in paragraph 3M3, it's basically talking to the seller. It says, hey, seller, if there's anybody living in the property here other than the seller, and the buyer doesn't submit a TOPA with their offer, you need to counter with one because you got to address this issue. And that's good. Now, sometimes the reason buyers haven't been using this form is because they have no idea who's in the property. They assume it's just the sellers. And when the seller says close of escrow will be date of possession, the seller is saying the sellers are going to leave. And when the sellers leave, they have to take their kids with them, believe it or not. They're minor children. So here's the question. Seller, the husband and wife, they have a older child in the property, 33-year-old son. He's not a minor child. He's not a tenant, but he's not a seller. He's not on the contract. So you close escrow and the buyer shows up and there's this 33-year-old guy on the property. And the buyer's like, who the hell are you? I'm the son of the seller. He says, why are you here? He says, nobody said I had to leave. And they're right. Number one, they never signed a lease saying they had to terminate. They're not a tenant, but they're not a seller either. And they're not a minor child of a seller. So you got to deal with this person. That's why it specifically says now, seller, you have to disclose to the buyer everyone who's there, not just tenants, anyone who's living on the property, you got to tell the buyer. So we're encouraging you to use the TOPA form. But I've got even better news for you. Let's say for some reason, neither the buyer nor the seller produces the TOPA form. Here's the good news for you. Paragraph 7A now says, if there's no TOPA form, everybody agrees the property shall be vacant at close. So having said that, now you're all thinking, great, I don't need that stupid TOPA form. I'm just going to rely on 7A. That guarantees that at least the seller is promising everybody will be gone. And that is true. But you know why I would still recommend the TOPA form? For two reasons. Number one, the buyer still wants to know who's there. But here's the real reason I like the TOPA is, what are your rights? If you're a buyer, the property is supposed to be vacant at close. You show up at close or 2 days after, whatever. You show up on the day you're allowed to move in and there are people there. Do you have the right to cancel the whole deal? Do you have the right to delay closing until it's vacant? Or do you simply have to buy it and deal with it yourself? And if so, is the seller financially responsible? Of course. But the question is, the purchase contract doesn't say which of these rights the buyer has, but the TOPA form does. So you need that form. I recommend it to deal with it. In fact, if you're thinking along with me, I'm almost thinking it's a good idea to submit that form every offer you ever write, just on the off chance that there are people there at close. And I want to make it very clear in the contract what my rights as a buyer are in that scenario. Obviously, if it's a vacant property, you don't need the form. because if it's vacant now, you're assuming it's going to still be vacant, but maybe they'll move in the middle of escrow. You can't even count on that. Okay. All right. So that wasn't a new form. That was a change. Three more changes. So remember, I'm telling you 4 more forms. There's a new form that is related. It's mentioned in paragraph 11M. It's a new disclosure form. Every year there seems to be a new disclosure form. This form is called the Solar Advisory and Questionnaire. The initials of the form are SOLAR, solar. And this is actually required. When is it required? If you're listing a house that has solar power. Now you want to get super technical. Okay. It doesn't say the form is required. It says the seller is required to disclose to the buyer everything they know about their solar panels and solar system. Then it says seller may use this solar form to do that. Read between the lines. You might as well use the form that was created for the purpose of satisfying the seller's obligation to tell the buyer about their solar system. By the way, what are you telling? You're basically telling whether you own it or leasing it. If you're leasing it, how many when's it going to be paid off? How much is owed? What type of system is it? Blah, blah, blah. So I would more or less say it's a required form. If you have a listing with solar, the house has solar panel. All right. So that, if you're keeping score, is the 7th new form I've told you about. And that's the only one so far that you're probably going to use. Except for my one friend here who does do buyer broker. And you all probably should do it. Okay. 2 more things. One of them is, you know how if you're in escrow, you're doing a transaction, and you're using this form, as you all do, there's a lot of deadlines. You got a closing deadline. You might have a deadline to remove contingencies unless you made a non-contingent offer. Deadlines to make disclosures unless you already did those. Deadline to put in the smoke detectors. Deadline to open escrow. Deadline to do whatever, right? So you have to figure out deadlines. Let's say I got a deadline of closing, 45 days. And how do I figure out what the deadline is? Well, the day of acceptance is day 0. Then I count 45. When I'm counting, I count Saturday, I count Sunday, I count every holiday. I count everything. But then the last day, the 45th day, falls on a Saturday. Can't close till Saturday. Can't close till the next business day. Sunday. But what if the deadline falls on a holiday? Does that mean the deadline goes to the next business day? Well, it depends on which holiday. California keeps adding holidays. This year they added 3. So the question is, are all of these new holidays official holidays for purposes of this contract, for purposes of saying the deadline cannot occur on that day? Well, there's finally an answer. And the answer, it says in paragraph 25I, for purposes of this contract, a legal holiday is a holiday under Civil Code 7 or 7.1 and Government Code 6700. I know what you're thinking. Why don't you just list in the contract the legal holidays? And the Forms Committee is like, that keeps changing. There are too many of them. There are going to be more ones. So we're telling you, the realtor, you actually have to Google those code sections. So I did it myself out of curiosity. I Googled those code sections. What are the legal holidays in California? To my distress, I found out that Cinco de Mayo is not a legal holiday. Nor is Halloween. But you know what is? Lunar New Year. First day of the lunar Chinese New Year is now this year it happened. You know what else is on there? June 19th, Juneteenth. If you got a deadline that's occurring on June 19th, you go to the next day. So the only way to know is to check. So what can I tell you? All right, which leads me to the last change on the purchase contract, which is going to lead us to the, if you're keeping score, the 8th new form. Remember, the first 6 were buyer broker, which most of you aren't going to use. The 7th new form was the solar form, which most of you have to use if you have a listing. All right. Last page of the contract. There's a box. I always call it the broker box. This is where you fill it in. And both agents fill it in. Up until December, it automatically filled with your name, your broker's name, your DRE number, your broker's DRE number. Now, if you haven't noticed, it also autofills with your physical address, your email, and your phone number. Now, there's a significance to this. Prior to December, there was a blank line that said designated electronic delivery address. So each agent was supposed to tell the other agent, hey, if you want to send me something electronically, because that's what we do now, we don't hand deliver stuff. If you're going to send me like a addendum or whatever, counter offer, removal of continue, whatever it is, here's where to send it. Okay. So what we discovered is many agents wouldn't fill that in. So the forms committee said, let's try to make it easier. Let's autofill the form with each agent's email address. Of course, your default email address might not be the email that you want the other side to send documents to. Maybe you got a different email, maybe your assistant, your TC's email, you want them to use that one or whatever. So in other words, the way the contract works now is it says designated electronic delivery address, and the agent is supposed to check a box saying whether they want the email above, the email that's in the contract, to be their designated address, or do they want a different one? Okay, so it's probably easier to check a box than writing it in. On the other hand, we've noticed some agents aren't even checking those boxes. So in other words, they're not committing to the other side where they want documents sent to. Therefore, we have a new form. DEDA or the DEDAA, whatever. It's the Designated Electronic Delivery Address Addendum. The idea is, whether you're the buyer's agent or the seller's agent, you notice that the other agent doesn't check those boxes. So you now have the ability to send them a form and say, hey, you forgot to tell me your delivery address. I need it. And hopefully they'll fill it in. What if they don't? Well, that's another interesting question. A change that happened about a year ago was that, okay, up until a year ago, if I sent you an email, I've said this to agents for 30 years, when you send an email to the other side, you cannot assume they got it. They could always say, you sent me an email, I didn't seem to get it. Maybe it went to spam, or it's in my inbox, but I never opened it, which leads to another legal question. If I send you an email, it's in your inbox, but you don't open it, have you legally received it? You would think after all these years, the courts would have resolved that issue. They haven't. Which is why the advice we gave for years and years was, when you send an email, it's not really good enough until the other side responds, says, I got it.